Hello everyone and welcome to our webinar about limitation and exclusion clauses. I'm David Lowe, I'm a partner who leads our commercial contracts team, and I spend my whole time negotiating and drafting limitation and exclusion clauses.
And I'm Sean Adams. I'm a partner in our commercial litigation team, and I spend my time having people fight over limitation and exclusion clauses and seeing how they apply in practice when parties come to rely on them.
So Sean's here to keep me honest, because of course I can say whatever I like because I don't have to deal with when they go wrong. And so Sean's here to remind us that when it goes wrong, it really does matter what's in your limitation and exclusion clause. Now, the reason why we're having a focus on this today is because there's been an important Court of Appeal case on limitation exclusion clauses in the summer of 22. And we thought it would be useful to step back from that case and look at limitation and liability clauses more generally to understand the context of that case. And to do that, we thought it would be helpful to go through a template clause. And so you'll find a link on our website to that template clause that we're going to use today to discuss and go through.
So, assuming you've all been able to find that clause, which is always a good start, let's start right at the beginning. So, David, you're the person that drafts these things. When you start putting pen to paper, where do you start first? What's the first thing that goes in there?
Well, I can almost sort of do it with my eyes closed, which is, nothing in this agreement excludes or limits a party's liability for death or personal injury arising from negligence. And then something about fraud, and then something about fraudulent misrep. That's often the first clause that you'll find in any limitation liability clause. And the reason it's there is, well, under UPTA, the Unfair Contract Terms Act, you cannot in a contract exclude or limit your liability for death or personal injury arising from negligence. The courts have indicated very frequently that under public policy grounds, you cannot exclude liability for your own fraud. And there was a case that said if you didn't expressly mention fraudulent misrep, then your entire agreement clause might fall down. So it's routine to mention that you don't exclude or limit the liability for that.
So, on the basis that you can put that in with your eyes closed, and I suspect there's probably lots of contract drafters that are in the same boat, do you really need it? Does it fall into the category of something that's so obvious it doesn't need to be there at all?
Yeah, it's a good comment. And we'd all rather have less words in our contracts. There is a school of thought that says, as you said, Sean, that if the law already says you can't exclude liability, why do I need to write that all down again? It's just there in the fabric, in the background. We don't need to say it again. But it would be a bold lawyer to decide not to bother putting that clause in, because we don't quite know what happens if you don't put it in. And none of us really want to be this test case going to the Supreme Court to find out for certain how it falls. So although probably if you don't put the clause in, you'll be fine, you don't know it, you don't want to be the test case, so therefore we all put it in. And of course, nobody objects to putting those words in. Everyone accepts their standard words, nobody argues about them. So you just put them in really to be safe.
Yeah, that makes sense.
So Sean, turn to the next clause in our template is a long list of stuff that possibly heads of loss that you might want to consider excluding in certain situations. One of them is wasted expenditure, and that's a recent addition to our template. Where's that come from?
Yeah, and that's come out of the new case from earlier this year that you mentioned at the top. So that's come out of the Soteria and IBM case, which was the big case that went to the Court of Appeal this summer or this Easter on limitation of liability clauses. That case was all about a very large IT contract worth sort of £50 million to put the IT system in place, and then another £125 million over the next 10 years to maintain it and run it. Big fallout between the parties. The system wasn't delivered on time. All of this then ended up playing out in the courts. One of the really big money items, and when I say big money, about £80 million ended up turning on this single point, was whether Soteria could bring a claim for their wasted expenditure, being the money they wasted paying IBM and other expenses, despite never receiving the system that they contracted to buy. The judge at first instance found that they had prima facie a good wasted expenditure claim. So they had a good claim for about 120 odd million, I think it was, of wasted expenditure, but then proceeded to kick out the entirety of that claim on the basis of a limitation of liability clause that said there'd be no liability for loss of profits, revenue, or savings, you might be thinking in your head, well, hold on, you haven't said there anything about wasted expenditure, and I can see in our clause we've got profit, revenue, and savings as separate things. And that was effectively the conclusion that the Court of Appeal came to earlier this year, really focusing on the wording of this limitation clause and saying there is no reference in there to wasted expenditure, various other reasons as well, but actually reinforcing the approach that the courts will take when reading these clauses generally, which is to say these are carefully negotiated clauses between parties. We are only going to interpret that the same way as we would interpret a contract generally. And if you've not said in there you're excluding wasted expenditure, and the consequence of a contorted decision to the contrary is you lose an £80 million or £120 million claim, we're not having that. So the court reversed that decision. The Soteria claim stood. And I suspect as a result of the big money that turned on that, that's precisely why we now see wasted expenditure here as a standalone thing to consider when you're looking at negotiating that list of exclusions.
So if you don't say it, you don't get it, basically.
I think that's absolutely right. If you're not clear about what it is you're excluding, and particularly where you're talking about really onerous consequences on one party, where that's sort of playing out in practice, and of course it's always going to be with the benefit of hindsight, clarity, and the courts are really looking at the wording here.
Yeah, and that's the challenge, isn't it? Because it's only with hindsight do you discover what was the liabilities and risks that perhaps you should have been managing with your words, and it's inevitable, in my view, that you're going to end up not putting quite the word in when you drafted the contract to deal with the risk that eventually happens. And so I'm a bit cynical about this. I sort of wonder whether you would ever put the right word in to suit the court, if the court was determined to give the other party a remedy.
This is why I choose to sit on this side of the fence. I get to look at things with 2020 hindsight. I don't have to look into my crystal ball.
Yeah, and that's why certainly as a drafter, I sort of wary of just simply adding extra things in a clause to take out and exclude, because I feel it's inevitable I'll end up not including the word that really matters on the day, with which you'll be arguing about, Sean, in the court. So I think this emphasizes to me my personal approach, which is to be wary of long, complicated clauses because they are too easy to fail. And it might be better for parties just simply to focus on the key exclusions and the cap and accept that everything else they're liable for subject to the cap.
Yeah, absolutely. And that, I suppose, brings me quite nicely onto the next clause in our precedent here, which is jumping out at me, probably going in the opposite direction, because having talked about the importance of clarity and brevity, I see that we've got in there, and it'll be very common to people who are negotiating and reading these clauses, we've got a reference to indirect, special, or consequential loss. And all three of those things, I'd be intrigued to see what you think as to whether they all need to be in there.
Yeah, so of course, this is the exclusion of indirect loss clause. And so as you just query me, why do I put 3 words? David Lowe doesn't like using 3 words when one will do, so why has he got 3 words in here? And actually the case law says that indirect and consequential loss means the same thing. So there's a case that specifically says consequential loss means indirect loss, and indirect loss means secondum of Hadley and Baxendale, which is you can only recover that if you've got special knowledge. And so that effectively means the parties need to have specifically agreed liability for those kind of losses. So the word consequential isn't needed because it means the same as indirect, but we put it in all the time because everyone does, and it'll look slightly odd if you didn't. And it's easy, once you've agreed the principle to exclude indirect loss, it's easy to agree it. Now, of course, that word consequential causes confusion with our commercial colleagues who read the word consequential as its normal, natural meaning and as something that arises as a consequence. And that isn't what it means. It's got a special legal meaning of indirect loss. Special loss, well, the only reason it's in there is because you just normally see it in there. And I have to say, I've really struggled to find exactly what special loss is. You know, there is a concept of special loss in tortious liabilities and those things like that. But what does it mean in a contractual area? To be honest, I don't know. It's only put there because that's what you normally put in there. And certainly I'm starting to think not to bother putting that word in. And actually, certainly in short form contracts, just a short letter form contract, I'm quick to strip the wording back to just indirect loss and not mention the word special or consequential. But all of this begs the question, just what is indirect loss when you actually have litigation? What does fall into that pot? Sean, what is it?
Yeah, and in a couple of minutes, what is indirect loss? I mean, you've already covered the technical legal version of it, David, which is it's that limb 2 of the Hadley and Baxendale test, but without straying into giving everybody a legal seminar for the next half hour on 1850s case law. I think probably the best way for practical purposes to look at it is actually to realise that what is indirect loss in a practical sense is really much more limited than direct loss as a result of recent cases. So whilst people might think of direct loss and indirect loss as sort of 50-50 or two halves of the possible liability, actually direct loss is a much bigger pool, given the way the courts have interpreted that. A case of GB Gas back in about 2011 found that direct loss really can extend beyond what you might, normally think if you were seeing both of them as an equal share. But direct loss in that case extended to ex gratia goodwill payments to customers. It was stationery to update the customers about the issues that were being faced. It was additional borrowing charges, all that sort of stuff. So actually, in practical terms, whilst it's obviously important to think about any exclusion that you're putting in, even if that is just an exclusion of indirect loss, really, when you come down to fighting about these things, the pool of stuff that gets kicked out by saying there's no claim for indirect loss is probably not as big as you might think.
Yeah, and so certainly I find suppliers are keen to exclude indirect loss, really because we just don't know what it is and are worried that if it does manifest itself, it's uncontrollable, unpredictable, and therefore could be a very large number. So as a supplier, you're worrying about something that might never happen, but you're worried, so you want to exclude it. And I certainly say to customers that I don't think it's a big deal for them to agree to exclude it, because GB Gas showed that probably almost anything they ever think of as being reasonably obvious consequence in the circumstances is going to be direct loss and not excluded. So it should be an easy give to give the supplier something they really want to agree to an exclusion of indirect loss. And I certainly find it's sort of market standard now to normally in most contracts to agree to an exclusion of indirect loss.
Yeah, that makes sense. So to move on to our last clause, and you gave everybody who's still with us a little bit of a hint earlier as to where you think really the meat of the commercial bargaining is around these provisions. Would that be this final provision around the cap by any chance?
Yes, it is. It might be the last, but it's the most important one. It's the cap. That's the daddy of all of this. I'm a big fan of concentrating on the cap. I think when you look at the case law, generally caps are upheld. In fact, if I remember rightly, Sean, in your IBM case, the cap, albeit very high, £80 million caps worked, even though the exclusion of the wasted expenditure didn't.
It did.
Is that right? Yeah.
It is, yeah, spot on.
So I think the judge in IBM, he's been listening to my talks and training and followed my philosophy, because by making it the centerpiece, it makes it a commercial issue, and therefore we can draw our commercial colleagues into what is a fair allocation of risk between the parties, what should be the cap on liability, how much is it, and that will change depending on type of contract, the bargaining parties, the insurance that's available, the market sector you're in. But at least it gets a commercial discussion going about this, about what is otherwise a complicated legal area. Now, I said if you put a cap in, it works. That's slightly misleading, because there is a lot of discussion about whether caps and liability need to be reasonable. And the reason for that is because under the Unfair Contract Terms Act, there is a requirement that in B2B contracts, when you're on somebody's standard terms of business, that any exclusion or limitation of liability in the standard terms of business must be reasonable, and therefore any cap must be reasonable. And so that's why there's always a bit of angst about the cap being reasonable, because you set it too low, that might be unreasonable, and suddenly the supplier goes from a low cap on liability to no cap on liability. And customers will be quick to point out to suppliers at risk to make the supplier a bit more nervous and increase their cap to what the customer think is reasonable. But many of you will be thinking, well, hang on, standard terms of business, that doesn't really sound like, you know, a negotiated outsourcing agreement, for example. Surely standard terms of business is just back of invoice, small print, T's and C's of sale kind of territory. And indeed, if you go back to the before 1996, that was indeed what everyone thought, that you only worried about the up to reasonable requirement in standard terms. But then we had a case, another IT case, Sean, one of your favourites, I'm sure, ICL and St Albans, where it was found that although the contract was negotiated, the specific liability clause hadn't been negotiated, was on ICL standard terms, therefore had to be reasonable, and that particular cap was unreasonable and struck out, and ICL suddenly was left with an uncapped liability. And so ever since then, in 1996, we have all collectively worried about whether our caps are reasonable or not. I do wonder whether, if that case happened again today, whether the courts would be so quick to knock it out. Certainly, sure, my observation is the courts seem to focus on what the words mean, as opposed to using the big bazooka of UCTA to knock out the cap. Would be that your perception?
Yeah, I'd agree with that. I think we've probably come quite a long way in the last 25 years or so in terms of how the courts looking at these cases and interpreting them. And I'd be quite surprised if that was the result today in what was otherwise a heavily negotiated contract.
Yeah, but Sean's here, ready to take on your case to the Supreme Court to test this and make new law and get ICL and sales overturned. But of course, that's why nobody's challenged it, because of course that costs quite a lot of money and time, and nobody wants litigation unless they really have to. So it's uncertain when that case will be overturned and when the high watermark established drops a bit, so that we can be a bit more confident. One day it will, but it's been around already for 26 years now, so who knows when that will be knocked out. Anyway, I hope that you all found that a useful canter through a typical liability clause, and in particular covering this year's IBM case and the context in which it applies. Very much enjoyed doing this. Look forward to hearing from you.